In the area of live-in or domestic care takers, in terms of employees, for example, who are hired by families to take care of elderly parents or things along those lines, there's often a very huge issue over how many hours the live-in worker actually works. Of course, the person is on site 24 hours, 7 days a week. And there are usually, in these circumstances, very loose rules in terms of record keeping. It's an informal type arrangement, and the person oftentimes is even considered to be a member of the family. They dine with the family members, they might go shopping with the family members, they help keep the house in order and things along those lines. Sometimes we have situations also where the live-in worker might start out working a certain number of hours per week or per day, and that grows because as the arrangement develops and evolves, maybe somebody needs additional care or additional duties are given to the live-in worker. And always the live-in worker needs to be cognizant of whether they are actually receiving pay for the actual number of hours that they're working. New York State law specifically protects domestic care providers in terms of how many hours per week they work. If you're a live-in and you work over 44 hours per week, you are entitled to overtime. And you also are entitled to receive whatever the state's minimum wage is at that particular time, which of course changes from year to year. If you're paid, for example, a weekly wage or a monthly wage, you need to be aware of whether, because of an increased number of hours, that minimum wage is now no longer being met, or perhaps you're no longer receiving any overtime pay because the number of hours you're working times whatever the minimum wage is actually now your weekly wage or your monthly wage. It's a difficult situation oftentimes for live-in workers because if they do lobby for more money, the employer oftentimes is going to look for a less expensive source of labor. So a lot of times these particular types of clients are concerned about lobbying for increases in pay. But it's certainly something that can be actionable if an increase in pay is not given, and you should certainly seek the advice of an attorney in order to lobby for you and provide you with a very good strategy in terms of how to approach your employer in a way that's going to keep you employed and maintain your employment, but at the same time also get you what you're entitled to.